This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So Liebowitz has lost yet another case. Let's take a look at what's going on. This action concerns plaintiff's allegations that Getty Images posted more than 47,000 images associated with plaintiffs on its website without authorization. On appeal, plaintiffs contend that the district court erred in granting summary judgment in favor of Getty. So plaintiffs are challenging as to their claim for copyright infringement under 17 U.S.C. 501 and their claim for altering copyright management information under section 1202b3 of the Digital Millennium Copyright Act. So that's a typical claim for a Liebowitz action, would be copyright infringement and failure to include copyright management information, which is basically credit or attribution. On cross appeal, Getty contends that the district court abused its discretion by denying its motion for attorney's fees. So Getty didn't get their attorney's fees. That's weird. Let's see what's going on here. This is the case of Zuma Press versus Getty Images, and James H. Freeman is representing for the Liebowitz law firm. If you recall, Mr. Freeman has taken over many Liebowitz cases, probably because Richard Liebowitz himself can't represent in so many cases, and also he's probably not admitted to many court systems, especially after he's been suspended here or there, or disciplined or sanctioned here or there, and courts are getting less and less patient with him. It still baffles me that they're patient with him at all, but I guess the next time someone is impatient with me, I get to throw a bunch of Liebowitz documents at them and say, hey, until I reach this level, judge, you can't be impatient with me. I'm really sure that will work, aren't you? Plaintiffs argue the district court erred in granting summary judgment on their copyright infringement claim because issues of fact remain as to whether Getty held a valid license to use their images. So summary judgment, no issues of material fact to go to a judge in a bench trial as fact finder or a jury in a jury trial. The jury, of course, would be a fact finder. So if there are facts remaining to be found, we can't do summary judgment. Summary judgment is like judgment on the papers, judgment as it exists in the record at the time. So the parties build a record, they submit their motion for summary judgment, and the judge decides if there are no further disputes on the facts. And if that's true, then the case can be adjudicated on the record. To establish a claim of copyright infringement, two elements must be proven: ownership of a valid copyright, copying of constituent elements of the work that are original. The existence of a license is an affirmative defense. So an affirmative defense means we did the thing, and here's why we're still not liable, because there's something that makes what we did legal. Placing upon the party claiming a license the burden of coming forward with evidence of a license. We generally construe copyright licenses according to the principles of contract law. Here, a reasonable juror could find that Getty established the existence of a valid license. As the district court concluded, the undisputed facts in the record and the plain language of each of the agreements at issue establish an unbroken chain of authorization from Zuma to Getty. So get out your whiteboard, you're going to need to follow this. At the start, Zuma and New Sport Photography separately reached agreements with Corbis Corporation, a large photograph licensing agency, to license and distribute their respective images. Whereas Zuma's agreement with Corbis yielded Zuma a 40% royalty rate, New Sport's agreement with Corbis yielded New Sport a 50% royalty rate. Zuma learned of New Sport's favorable royalty rate, and it devised an arrangement with New Sport where it would submit its images to Corbis under New Sport's contract with Corbis, using New Sport's credentials and New Sport's FTP server. In turn, New Sport's royalty payments were redirected to Zuma. On November 3, 2011, Zuma and New Sport memorialized their agreement in a document titled Request for Redirection of Royalty Payments, the Redirection Agreement. This agreement specifically affirmed that New Sport was authorized to submit all images it sent to Corbis under its contract with Corbis, and Zuma was authorized to receive royalty payments due to New Sport under its contract with Corbis. Plaintiffs concede that Zuma delivered all the images at issue in this action to Corbis for distribution under New Sport's contract with Corbis, using New Sport's FTP channel and credentials. New Sport's governing contract with Corbis vested in Corbis the right to use, reproduce, publish, exhibit, perform, publicly display, distribute, broadcast, and transmit the images. It also authorized Corbis to assign its rights and obligations to any surviving party as part of the corporate reorganization, consolidation, merger, or sale. Corbis exercised that right in January 2016 when it sold its image portfolio to Unity Glory International, Unity Glory. And Unity Glory soon thereafter entered into an agreement authorizing Getty to distribute and market outside of China all the images it acquired from Corbis. Getty ultimately obtained the images at issue in this action as part of its agreement with Unity Glory. Given the plain language of each of these agreements, there can be no dispute that Getty obtained a valid license to use the images when it entered into its agreement with Unity Glory. To the extent plaintiffs argue that issues of fact remain as to whether Getty held a valid license because they can adduce evidence indicating that Zuma and New Sport terminated the redirection agreement, they miss the mark. By the express terms of New Sport's renewed agreement with Corbis in 2012, Corbis was entitled to use the licenses for at least a period of 6 years, including a 3-year initial term and a 3-year survival term. Getty posted the images at issues to its website and took them down from its website by June 2016, well within that time frame. We therefore conclude that the district court did not err in granting summary judgment to Getty as to plaintiff's copyright infringement claim. Now, what do we know about Liebowitz? We just had the Aaron Carl interview where it was very clear that Liebowitz did not investigate or understand or something, a little bit of speculation here, that the Facebook terms of service allowed the use of the plaintiff's image, Mr. Bradley's image, that Aaron Carl made on her Analytical Grammar Facebook page. The Facebook terms said you can use this image. Anybody can use a publicly posted image. And Facebook has changed that from what I understand, but it was legal back then. And so Aaron Carl and Analytical Grammar won that case. It was a great interview. Go watch it. I've posted a bubble. Does that then indicate that Liebowitz does his due diligence and finds these things before he sues, or he sues first and asks questions later? I think it sounds like he sues first and asks questions later. So I kind of see how that happened. On the DMCA copyright management information section, plaintiffs argue that the district court erred in granting summary judgment to Getty as to their claim for altering their CMI, copyright management information, without authority under the DMCA because there is a genuine dispute of material fact as to whether Getty knowingly altered their CMI without authority, or 2, had reason to know that distributing the images would induce, enable, facilitate, or conceal an infringement. We disagree. We recently explained that to establish a violation of the CMI section of the DMCA, 1202b3, the plaintiff must prove the existence of CMI in connection with a copyrighted work, that the defendant distributed the works or copies of the works, while knowing that CMI has been removed or altered without authority of the copyright owner, and 4, while knowing or having reasonable grounds to know that such distribution will induce, enable, facilitate, or conceal an infringement. So it's not just the removal, but also has to be connected to inducing, enabling, facilitating, or concealing an infringement. The last 2 of these elements comprise a so-called double scienter requirement, a double knowledge requirement. The defendant who distributed improperly attributed copyright material must have actual knowledge that CMI has been removed or altered without authority, as well as actual or constructive knowledge that such distribution will induce, enable, facilitate, or conceal infringement. The statutory definition of CMI encompasses, among other things, the name of and other identifying information about the copyright owner of the work, including the information set forth in a notice of copyright. Here, no reasonable juror could conclude that Getty knowingly removed or altered plaintiff's CMI without authority. As the district court concluded, there is no evidence in the record on which plaintiffs can rely to establish that Getty had actual knowledge that the images at issue were commingled with the New Sport collection. On the contrary, a reasonable juror could conclude only that Getty did not know about plaintiff's purported rights in the images until Zuma contacted Getty May 4th, 2016 to complain explained that Getty did not have authorization to use the images, that is, until after Getty had completed the migration process and posted the images to its website. Getty promptly thereafter removed whatever images it could identify as associated with Zuma from its public-facing website and launched a full investigation into what happened. A reasonable juror could find only that the purported changes to plaintiff's CMI resulted not from some intentional act of which Getty was aware, but from aberrations and mistakes in the automatic migration process itself, during which Getty processed approximately 7 million images. For example, the appearance of a double byline in the metadata of the images resulted from the original inclusion of Zuma's attribution information in Corbus's free text caption field, as opposed to Corbus's photographer name or agency fields. The engineers who developed the migration process did not account for the possibility that CMI would appear in the free text caption of any image. So it sounds like there was an attempt to migrate the information and it went bad. Contrary to plaintiff's contentions, Getty's post-migration communications fail to create a dispute of material fact as to whether Getty had actual knowledge that it altered plaintiff's CMI when it undertook the migration process, let alone that it did so without authority. Although the June 27, 2016 email chain that plaintiffs reference vaguely suggests that someone named Les Walker may have had a Zuma conversation with Getty at some point previously during the migration to Getty talks, Walker flatly testified at his deposition that he was unaware that the images were even in the Newsport collection prior to the migration, and that he did not discuss the images with Getty until after the migration. Likewise, the May 5, 2016 conversations that plaintiff references, in which employees investigating Zuma's complaint suggest that Getty may have been aware of the Zuma thing, is insufficient without more to impute actual knowledge of Zuma's supposed ownership of the CMI to Getty, particularly given that one of the Getty employees noted in the same conversation that other than the caption, there is no indication in the Corbus data that the images belong to Zuma. We therefore conclude that the district court did not err in granting summary judgment to Getty as to plaintiff's DMCA claim. Because we conclude the plaintiffs cannot establish that Getty knowingly removed or altered their CMI without authority, we need not consider plaintiffs' additional contention that there is a genuine dispute of material fact as to whether Getty knew or had reason to know about infringement, that second part. On attorney's fees, we review a district court's denial of the application for attorney's fees for an abuse of discretion. So we've heard of de novo or brand new. This is for abuse of discretion. Was there an abuse of the court's discretion? Getty contends the district court abused its discretion in denying Getty's motion for attorney's fees because 1, it failed to adequately explain its denial of Getty's motion, and 2, the totality of the circumstances warrants a fee award as a matter of law. We disagree. Section 505 of the Copyright Act and Section 1203 of the DMCA endow district courts with broad discretion to award reasonable attorney's fees to a prevailing party. Of course, that discretion is not without limit. The Supreme Court has set forth several principles to guide a district court's discretion in considering a motion for attorney's fees. See Kurtzsang v. John Wiley & Sons, the Dummies Book case. First, a district court may not award attorney's fees as a matter of course. Rather, a court must make a particularized case-by-case assessment. Second, from Fogarty v. Fantasy, a court may not treat prevailing plaintiffs and prevailing defendants any differently. Third, several non-exclusive factors, the Fogarty factors, may inform the district court's analysis, including frivolousness, motivation, objective unreasonableness, and the need in particular circumstances to advance considerations of compensation and deterrence. A district court should give substantial weight to the objective reasonableness of the losing party's position, all while giving due consideration to all other circumstances relevant to granting fees. As an initial matter, we reject Getty's contention that remand is warranted on the procedural ground that the district court failed to adequately explain its decision. To be sure, as Getty notes, the district court's analysis was limited to a recitation of the factors it considered in arriving at its determination, and a recitation of the applicable factors of legal standard, standing alone, is normally not sufficient to permit appropriate appellate review of a district court's fees decision. But we need not remand for any further explanation where the reasons for a district court's decision are clear. Here, although we would have preferred the district court provide a more detailed account of how it applied the facts of this case to the factors it considered, the basis of its decision is clear to us, and we are satisfied that it undertook the particularized case-by-case assessment that Section 505 demands. As to the merits of Getty's motion, the district court acted within its discretion in concluding the plaintiff's claims were objectively reasonable, non-frivolous, and properly motivated. Plaintiff's copyright infringement claim concerned a complex set of facts, which plaintiffs reasonably argue resolved in their favor. Plaintiff's DMCA claim turned on the DMCA's double scienter requirement, which this court had not construed in a precedential opinion until well after the district court decided plaintiff's motion for summary judgment. That case was Mango rejecting the appellee's request for attorney's fees incurred in defending the appeal because the interpretation of Section 1202b3, the CMI section, was a relatively novel issue and a question of first impression for the court. Moreover, outside of its assertion that plaintiff's claims were motivated by the prospect of unjustified statutory damages, Getty points to little in the record to undermine the district court's finding that plaintiffs brought this action for proper motives. We therefore conclude the district court did not abuse its discretion in denying Getty's motion for attorney's fees. We have considered the remaining arguments, find them without merit. We accordingly affirm the judgment and order of the district court. So Liebowitz loses the case, but doesn't have to pay attorney's fees because the case was otherwise handled properly. Bravo! Bravo, Mr. Liebowitz and Mr. Freeman. Attorneys Liebowitz and Freeman for getting through a case with at least the appellate part of the case without any sanctions or attorney's fees. But it does turn out that there was a chain of licenses, and Getty did observe those licenses. It sounds like they had the right to put the images up on their website for sale, but they took them down as a precautionary measure anyway, and there was something about 6 or 7 years or something, so it looks like they observed licenses, which that sounds like something Getty would do. I understand that things happen. Getty's not perfect, but I would expect that Getty Images would be a more reliable licensing, or more reliable on evaluating the licensing of the images that they're putting up on their website. Let me know what you think of that one in the comments below. So that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, also on Floatplane and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern U.S. time. We are a community-supported legal education channel. We thank you for your support on patreon.com/ljfrench, sponsors.com/law, through Floatplane membership and YouTube membership. Thank you very much in the month of March to the following $50 plus supporters: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Andy, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Brandyn, Abel, Torpedan, Cassandra, Curran, Sovereign Tittizen, ShadowTycho, RDHDragon, and Earthbound Star. And thank you to the $5 plus supporters. Everyone will be scrolling on the screen in front of me. You're on the fake LED panel behind me, which we're using as a substitute for now until I make a new one. I love you all. I'll see you in the videos that drop. Have a great week. Bye.
I'm not a cat.
The last two of these elements comprise a so-called double scienter.